4, 5, 7. Right, 2, 3, 4, 5. We're waiting for Ron, is that right? Otherwise known as Commissioner Solomon.
That's right. I'm helping him join right now. Hey, good morning, Dee Dee. Do you have a question?
Mr. Chair, my apologies. It is displaying an incorrect name for me, and the feature will not allow me to rename. May I request that you rename me? It's Nat, N-A-T, Dean, D-E-A-N. My apologies.
Okay, thank you, Miss Dean.
I just changed it. Just make sure that it's displaying correctly for you as well.
There it is. And there's Ron. Good morning. All right, we now have what appears to be a full complement of commissioners. And to make sure that's accurate, I'll call the roll. Commissioner Baker.
I'm here.
Commissioner Bluestone.
Here.
Commissioner Castillo.
Present.
Thank you. Commissioner McMillan.
I'm here.
Commissioner Solomon.
Present.
And Commissioner Villanueva.
Here.
Chair is present, so we have a full complement, as I said. Next item is approval of the agenda. Is there a motion and a second?
Chair, if you don't mind, the staff would seek a motion to remove item 5, advisory opinion 2024-03 from the agenda. We received an additional request that's related to this advisory opinion on a separate question, but the analysis of that question might inform the analysis in the advisory opinion, and we're just not comfortable asking the commission to issue it today.
Thank you. Anybody opposed to that? I assume not. Hey, Jeremy, your sound was a little wonky there, so just be aware of that. Your microphone.
All right, appreciate it.
All right, any other motions relative to the agenda? If not, I will seek a motion and a second to approve the agenda
So moved.
as edited.
Okay.
Thank you. It's been moved and seconded. Is there any opposition to the approval of the agenda? Hearing none, the agenda is adopted. Next item is the approval of the minutes of our last meeting, which was held February 2nd of this year. Is there a motion in a second?
So moved.
Thank you. There's a motion and a second. Any objection? Not, the minutes of the February 2nd meeting are approved. We'll now get into the meat of the matter. Item number 4, advisory opinion 2024-02, which is Ms. Randall and Ms. Meunier. Folks, it's your play.
Morning, Chair, members of the Commission. I'm here to present advisory opinion number 2024-02. Commissioner Baker last month requested that this opinion be converted to a formal advisory opinion. It was initially requested by a legislature back in May of 2023. I was sort of randomly appointed, as we were at the time, to prepare an advisory letter, and this was the analysis and question presented that I prepared at that time. Essentially, a legislator had requested whether she could use campaign funds to pay for registration and travel to a conference and attend. She was not specific as to the extent of the conference, but it was intended to specifically make her a better legislator. and was sort of a professional development course. So in our analysis, we point out this Campaign Reporting Act that gives us sort of an exhaustive list of permissible uses of campaign funds, and also expressly prohibits a certain sort of non-exhaustive list of personal use or things that are deemed personal use. And so I think this was an important question to address because it points out that distinction and is a case-by-case basis as to whether that particular legislature can articulate whether that travel and conference is narrowly or reasonably related to their legislative functions, as opposed to something more broad or overly broad that sort of converts itself into personal use and just a vacation or travel not reasonably related to the legislator's functions. The only other thing I would point out is that the CRA legislatures have sort of carved out that exception for themselves specifically, where types of elected officials cannot use campaign funds for things that are reasonably related to their functions as an elected official, but the legislature certainly can, even after campaigning is complete. So I think that's sort of the over umbrella sort of gist of the opinion. And I'm assuming you guys could hear me okay. I apologize, I didn't ask that before I started talking. And I stand for any questions.
All right, let's first move to see if we have an emotion second to issue the advisory opinion and then open it to questions. Is there a motion a second?
So moved.
Second.
Thank you. All right. Questions, discussion. Mr. Baker, you have anything?
No, I just assumed that on a case-by-case basis, somebody could take issue with the quality of one of these classes or one of these seminars. But as a broad statement that helping somebody become a better legislator seems like an appropriate use of excess campaign funds.
Yeah.
And I would just ask Commissioner McMillan, since he served in the legislature, if he had any real life experience with respect to any of these classes that are offered.
Sir, if you care to answer, if you don't care to answer that, that's fine too.
Chair, I personally, I never took advantage of using campaign funds to pursue any traveling. Having said that, the invitations, which are legitimate, do exist and come around. Our legislators get little in the way of education about the process of a legislature and how bills get made and how to best and most effectively serve their constituents. So I think it's legitimate if a legislator chooses to attend and use campaign resources to improve himself in those ways or herself. Certainly, what would be legitimate is open to interpretation. And a couple of examples were given in the opinion, which were apropos. But I don't have any difficulty with a legislator using campaign funds so long as it is clear that the trip is to improve their ability to serve their constituents. And the interpretation there would be left to our ethics commission, I presume, if a complaint is lodged.
Yeah. Fair enough. Thank you. Commissioner Bluestone, anything?
No, I think it was well done and pretty straightforward. I appreciate it being put into a formal opinion. Thank you.
Commissioner Castillo?
I don't have any questions. Well done. Thank you.
Commissioner McMillan, you have anything to add to what you've already said?
No, thank you.
Thank you. Commissioner Solomon?
No questions. Thank you, Chair.
Commissioner Villanueva?
No, nothing. Thank you.
Okay, no questions from the chair. So there's been a motion and a second, no further discussion. Commissioner Baker,
I vote in favor.
Commissioner Bluestone
Yes.
is frozen.
I said yes. I vote in favor.
I'm sorry, it just didn't come through it was a technical glitch. Commissioner
Okay.
Castillo,
Yes.
Commissioner McMillan,
Yes.
Mr. Solomon, that a
Yes.
yes? Yeah, okay, thanks.
Sorry.
Yeah, I don't know whether it's on my end or your end.
So it was-
Villanueva
Yes.
and chair votes yes. Thank you very much, for your good work on that. The advisory opinion shall issue. Number 6, Annual Open Meetings Act Resolution.
Good morning, Chair, members of the commission.
Hi, Casey.
The Open Meetings Act resolution is back on the agenda. It was brought to our attention that the notice provisions could be a little bit clearer. While the commission has been providing all of the notice required by law and is otherwise provided in the resolution, the concern is in the paragraph relating to the commission's bi-monthly meetings. This comes from the Attorney General's guide on the Open Meetings Act, and really the regular meeting provision in their recommendation would relate to a meeting that, for example, that was held at Tuesday at 9 a.m. every other Tuesday. But while the commission usually meets at 9 a.m. on the first Friday of every other month, because it doesn't always, that notice can't be included in the resolution itself. And so what this draft does is simply updates the notice language across the provisions to match the language of the law and to make it consistent across all of the meetings. And I will stand for questions.
Thank you. Is there a motion and a second?
So moved.
Right. Any discussion? I'll not be quite so precise as I was last time, but I'll start with the obvious. I'm limited by my lack of imagination, so I just look to the alphabet to guide me. Jeff, that means we'll start with you, and those of you who follow and be ready. Anybody?
Thank you. But
Anybody have anything?
I do. I do.
Oh, go ahead. Yeah, Judy.
Yeah, if I could get some clarification or explanation on Article 4, Provision 4, where it talks about will be held only under unforeseen circumstances that demand immediate action to protect the health, safety, and property of citizens or to protect public body from substantial financial loss. Which is the emphasis there? Is that it is an immediate issue, or is that it's an issue of public health and safety, etc.? Because I've heard it argued before that every issue of law, it basically is a matter of public safety and property. So is the emphasis on the immediacy of it?
Yeah, Chair and Commissioner Villanueva, that's correct. That really the emergency provision is when the commission can't otherwise provide the full notice that it would require for a regular meeting. That if it's something I have a hard time coming up with something that this commission might run across, but it's possible where within 24 hours notice you need to have a meeting in order to meet one of these circumstances. And that otherwise you can't, that a full 10 days would be too long. That would, that the harm to the health, safety, property, substantial financial loss would occur during that 10-day time frame. So yeah, the focus there is on the immediacy issue.
Okay, thank you very much, Casey.
Thank you. Anything else? All right, there's a motion and a second to adopt the resolution. Commissioner Baker? Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. Motion carries. The Open Meetings Act Resolution 2024-01 as presented is hereby adopted. Item number 7, Jeremy.
All right, thank you, Chair. Commissioners, this is a resolution that I've prepared for you after encountering the Commission's first 30B6 deposition where the commission was deposed in an IPA-related matter, and I sat as the commission's representative in that deposition. And on the run-up to that deposition, Walker and Casey and I spoke about the line of authority for who would represent the commission in 30B6 depositions. And we began to think about it. And as you know, it's a basic principle of administrative law that agencies only have the authorities that the legislature and the Constitution confers upon them. And folks that work at administrative agencies only have the authority that is conferred upon them through statute or rule. And there's a number of job functions that I've done for the commission since its inception that I think are implicit just in the role and the authorities of the executive director. But what this resolution does is it just tries to fill in some of the gaps and create clear lines of authority for the executive director doing their job. One of them has to do with representing the commission in 30B6 depositions. We're now far enough along where we're engaged in litigation where our opponents will take the corporate deposition, a 30B6 deposition of the commission. And I think there needs to be a clear line of authority as to who represents the commission in 30B6 depositions and binds the commission in court. And what this resolution does is it says that the executive director can do that, or the executive director can appoint someone else to represent the commission in a 30B6 deposition. And that will often make sense when the commission itself is a party in the litigation, and the executive director will need to be a lawyer for the commission and thus appoint someone else to be the designee in the deposition. Related to that, the resolution also seeks a ratification of instances where I've sat for the commission as its corporate representative. Next, the next kind of gap filling measure that the resolution does is it authorizes the executive director to speak in ways that are related to legislative activity. So for the past 4 or 5 sessions, I've gone into committee rooms, I've spoken on bills, I've presented bills, I've negotiated with legislators about bills. Some of you have been there for that. Dr. McMillan most recently. I've asked the governor for messages. I've asked the governor for vetoes. And all of this, I think, is implicit in the ED's job to try to promote the best ethics statutes that we can during the session. That's nowhere in statute or rule, that's part of the executive director's job. And that's part of what this resolution does as well. There was an initial draft that was too strong. It articulated that the director would speak for the commission, and Commissioner Bluestein rightly suggested that that's probably not necessary and too much. And so that's out of the draft that's before you, and it just simply says the executive director may speak on any matter that relates to legislative activity. And I think that's part of the director's job, and it's been part of what I've been doing for you for the past 4 or 5 years. And then last, the remaining gap filling authorization relates to the commission's authorization for subpoenas. In our administrative case docket, there are times when the general counsel needs a subpoena in order to properly investigate a witness. And there are two junctures where subpoenas are necessary in our administrative proceedings. In the investigatory phase, where the general counsel is working on his or her findings, and then at the hearing phase. And instead of the commission just always approving the hearing related subpoenas, which can be a bit complicated, and that relates to the next item on our agenda. I'm going to ask for your approval to authorize the staff to seek a leave for subpoenas with Judge Hunter. Hearings get moved around, and the commission only meets every other month. And so we're asking for a kind of blanket authority whenever the commission authorizes an investigatory subpoena in the general counsel's investigation, should that case go to a hearing, the commission also authorizes the seeking of a subpoena to compel witnesses at hearings with Judge Hunter. And that will just, what that will do was it'll take the necessity of having to come back to the commission and ask for subpoenas related to the hearings. And that necessity, as I'll mention in the next item on the agenda, has required a hearing with Judge Torgerson once before. And so we don't want to be in the position of doing that again. And so what this resolution does in its final moment is just request that whenever the commission authorizes a subpoena for investigation, should subpoenas for hearings be necessary to compel witnesses at the hearing, the commission also gives that authority. And so, Chair, that's a brief summary of the resolution before you. It's kind of a gap filling resolution for gaps that we've identified along the way.
Thanks, Stuart. For the those on the commission and those in attendance who are unburdened by a knowledge of the law as deeply as some of the rest of us, would you just briefly elaborate what a 30B6 witness is? It doesn't necessarily flow from that, and probably everybody knows, but I'd rather know that we've discussed it rather than not.
Sure, but I think Jeremy can answer the question
I
directly.
was looking at you and I meant Jeremy.
Yeah.
I'm sorry.
Sure, I'm happy to. So a 30B6 is a kind of deposition that's allowed for in the state rules of procedure, same as in the federal rules. It's a way for a party to take the deposition of a corporation or a government entity. And in that instance, the corporation or the government entity, because they're a fiction of the law and they can't speak for themselves, they have to appoint someone to speak for the corporation or the government entity. And when that person does speak for the corporation or the entity or an association in a deposition, the representative's testimony in the deposition becomes binding on the corporation for purposes of evidence at trial. And it's 30B6 depositions can be used in a variety of ways. They're very helpful and they're very common in civil litigation. And the fact that we're now involved in having our 30B6 deposition taken and taking the 30B6 depositions of witnesses and corporations in cases that we're litigating, that's natural. That's part of the unfolding of the work of this commission.
Okay, thank you, Stuart. All right. So is there a motion and a second to adopt the resolution?
So moved.
Second.
Thank you. Discussion, starting with you, Jeff.
No, I think it's appropriate that the executive director have the ability to designate somebody to be a 30B6 witness. And this just makes that authority clear cut.
Thank you. Commissioner Bluestone, I know you had some concerns about this.
Yes, thank you, Mr. Chairman. And thank you, Jeremy, for the explanation. I actually think that the executive director has all this authority as implicit in the way the executive director does the job, given the constitutional and statutory authorizations that are provided. So I don't really believe that it's necessary, but I don't intend to object to Jeremy's effort here to try to put it down in a resolution. The concern I have is that by putting it in a resolution, if there are other things that are still implicit in the executive director's authority, that by not including them in this resolution, that we're kind of opening ourselves up to having to have arguments that he or she doesn't have that authority unless there's an express provision like this resolution. But even though that's a concern I have, I don't think that given Jeremy's interest in wanting to go forward on this, that I would object to doing it. And I certainly think that these matters are generally all appropriate, particularly the 30B6 references and the subpoena reference, which could be done on a case-by-case basis, but I think it's fine to do it this way too. The concern I have, and Jeremy was helpful in responding before, in taking out the words that the executive director may speak, instead of saying for the commission, took those words out. And I think that's helpful to let it be clear that the executive director just speaks as the executive director. But I have a couple of concerns about this number one. One is, and it's not a concern at all directed towards Jeremy, we're just talking institutionally for the future. When it says that the executive director may speak in any matter that relates to legislative activity, I think that's too broad, because there could be matters that don't concern the work of the commission that an executive director may want to speak on, either an appropriation or something else. And so I think it would be good to end number one with a phrase like, so that it would read, the executive director may speak in any matter that relates to legislative activity, etc., or any other statement or request regarding legislative activity that reasonably relates to a matter the commission has approved. So that it's not an open-ended thing on any and all legislative matters, but that it relates to matters that we as the commission have approved. And then related to that, I think I'm concerned that given that third whereas clause, that whereas from time to time, considering the nature of the commission's business, an individual must represent the commission or speak on the commission's behalf. I think there's an implicit reading here that when the executive director speaks, he does speak on behalf of the commission. And I think he usually or she usually will, but I think we need to clarify that the executive director may speak in the capacity as executive director, and not necessarily on behalf of the commission, in any matter that relates to legislative activity, etc., that reasonably relates to a matter the commission has approved. So I'd like to throw those out for discussion and make a motion to amend number one with those two changes. And then as I'm looking at it here, and maybe Commissioner Villanueva would have commented on this anyway, but I think there's a typo in the last whereas clause where it has a semicolon after the NMAC site. And I think that probably should just be a comma. And those are my comments, Mr. Chairman.
Thank you. Commissioner Castillo?
Thank you, Chair. When I first saw this, I had the same observation, I think that Stuart did, that because the executive director has already done much of this in the past in his capacity as executive director, this is not really necessary, because the commission has never objected to Jeremy's work on the commission's behalf. And in fact, we have impliedly assigned him those duties. So I did talk to Jeremy to find out the basis of this, and he was very good about explaining what he thought was necessary. And he also told me that he really there's no job description for him. So I also have a concern that Commissioner Bluestrom brought up about this may limit what he can do. And I don't want it to be limited, because what he needs to do is all the things that he has done to make sure that the mission of the commission continues. So I'm not gonna I agree with Jeremy. If Jeremy wants this, I think that we ought to do it. But I think we ought to look at an expansive job description that might include generally all the things that he does, so we don't have to come back and do this piecemeal. So, and as far as the language is concerned, Stuart's concerned about the language, I don't have any objections to that.
Thank you. Commissioner McMillan?
Thank you. Just briefly, I do support the resolution, and that for the primary reason, I understand the arguments, perhaps against consideration of not so specifically outlining the executive director's responsibilities in these matters. Yet it gives Jeremy a footing when questioned if he executes his duties as addressed in the resolution. He has clearly something to stand on should his actions be questioned by another entity. So I support the resolution. And further, I would agree with Commissioner Bluestone about the proposed minor amendments to further clarify them. So that's all I have for now.
Thank you. Commissioner Solomon?
Chairman, thank you. I support the resolution as well, especially as identified by Commissioner Castillo, that we don't have a job description. It's very hard to function in that kind of, especially in that kind of environment, the legislative environment in particular. And I also support Stewart's suggested amendments to the resolution language. Thank you.
Thank you. Commissioner Villanueva?
I support the resolution, and in particular, with respect to Commissioner Bluestone's recommendations, I support those as well. I do understand his concern. I really have no further comments on whether or not it would be limiting. I guess if Jeremy is comfortable with it, I'm fine with the way the resolution reads. In particular, I would agree with Commissioner Bluestone's semicolon to a colon.
To a comma.
Chair Lang,
To a comma. I'm sorry, to a comma.
Chair, before you vote,
Yeah.
I want to say that the one part of Commissioner Bluestone's amendment I think is unfriendly, and it's the notion that the executive director could only speak on legislative activity to anything that's reasonably related that the commission has approved in the past tense. That's just not the way the session works. Things can come out of the woodwork. There can be new bills dropped that relate to ethics in the state of New Mexico that can relate to just to the mission of the agency. And the commission approves every year a set of recommendations to the legislature and the governor on a certain set of statutes to amend. And so what the commission has approved is, could be quite narrow with respect and in comparison to what can come up in the roundhouse during the legislative session. And I think that the director just needs to be, if we're going to give a clear line of authority to the director, it needs to be broad enough so that the director can respond appropriately to bills that we haven't anticipated, but which very much could affect the commission statute and its works.
Yeah, that's my concern as well. And I had a note to that effect, that if the commission has not specifically approved something and it comes up in the form of any type of an amendment or a new bill or a substitute bill or anything like that at the legislature, you can't take a timeout and go back and have a discussion with the commission to make sure we have all approved it. And so I think, Stuart, you probably recognize that as well. And maybe it's just some workshopping on the language, but that it's reasonably related to the work of the commission.
Right.
I would agree with that.
Okay. You okay with that, Jeremy?
I am. That'd be fine.
Yeah, I think that probably solves it. And even though it is implicit, I do like the ability to specifically state that the ED is speaking on behalf of. It goes without saying that if he signs something or introduces himself as the executive director of the commission, that legislative bodies or any other individual or entity before whom he appears is going to take it, whether we have expressed it, especially given it to him or otherwise, that he is speaking on behalf of the commission. It is a given. I think setting it forth obviates the need to explain to a legislator or an individual when somebody says, what authority do you have? And not get into that and delay it or throw it off track. He can specifically point to this. And I recognize that maybe you don't think of everything, but I think there's enough of a catch-all to where anything is reasonably anticipated by setting it forth as it is in the resolution. So with the motion and the second were made, with the movement and the seconder accept the friendly amendment. And Stuart, articulate that again, because I've already forgotten what I said that you agreed to. It was
Regarding
business.
legislative activity that relates to the work of the commission.
Yeah.
It reasonably
Is-
relates to the work of the commission. Yeah.
Right. And is that acceptable to the movement and the seconder, whoever they were?
Yes.
If I was the movement, I don't remember, but sure.
I think you were, and I think
seconded.
Celia, you seconded. There you go. By executive decree. Okay, and the semicolon will be changed to a comma where appropriate. So with those modifications or amendments, Commissioner Bluestone, how do you vote? Or, I mean, Commissioner Baker, how do you vote?
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. The motion as amended, the resolution as amended is adopted. Thank you, folks. Good work. All right, the next matter, number 8, is the administrative complaint number 2227.
Okay, thank you, Chair Commissioners. This is the administrative case of Brett Kokonas versus Karen Bedoni, number 2022-027. Judge Torgerson has set this case for a hearing on May 13th and 14th. And in anticipation of that hearing, because Walker and Jessica are informed that there'll be witnesses that will be unavailable, that they need to take the testimony of at the hearing. We need to go to Judge Hunter and seek a subpoena to compel those witnesses to be present at the hearing. And all I'm doing is asking for your authorization to file a petition with Judge Hunter for leave to issue subpoenas to compel witnesses at the hearing of Kokonas versus Bedoni.
Thank you. Is there a motion and a second?
So moved.
Thank you. It's been moved and seconded. Is there any discussion? If not, Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Let the subpoenas be sought. Okay, item number 9. Stuart?
Thank you, Mr. Chairman. This is that draft piece that you've seen in prior months, but it's been revised and presented to the commission now. And I recommend it for its review and approval. I believe it furthers the commission's important public education role to keep the public and public officials and employees well informed about important governmental ethics issues. And I think this procurement code is an important one. It's one of the laws that we have oversight over. And now that the legislature in this last session has approved even more record-setting amounts of hundreds of millions of dollars that will be awarded in contracts under the procurement code, I think it's important that we as the commission remind everyone involved of the parts of the procurement code, namely that it's a merit-based system with objective evaluations and awarding of contracts, and of the 2 key guardrails in that system, so that no public officials or employees can play favorites even before the process begins or after the evaluation process ends, and they can't change things. It's generally worded and purposefully done so as to avoid mention of any particular case that we've ever dealt with. It's been amended a number of times in the last 6 months since we've first seen the first draft. And now that the agencies are getting ready to release RFPs and award these contracts with the start of the fiscal year on July 1st, I think now is the time to release it. So I think the bottom line is that if you believe that we as the commission think this is a good public service education message about the procurement code, that the commission should endorse and approve it. And so with that, I move the commission approve this public education piece and distribute it under this one titled Procurement Code Ethics and Important Protection Against Public Corruption in New Mexico. And then, as is almost always the case, like before with the resolution, I do see one typo in the very first line. The word 100 should be changed to hundreds to make it hundreds of millions. And then I'd like to defer to Commissioner Foy Castillo to offer a couple of clarifying language amendments regarding a couple of the paragraphs to again keep it general. And she's explained these to me and I agree with them, and I'd like to defer to her to explain those before we vote on the piece.
Sure. And just so I'm clear, Stuart, and I think I am, but you are moving that this be adopted as a publication by the commission, correct?
Yes, sir.
Thank you. All right. So Commissioner Castillo, I will look to you as a seconding voice. Is that accurate?
That's accurate.
Okay. So in your seconding speech, you have some amendments to the motion.
Yes, it's an amendment to the op-ed itself, and I can't help myself. Having written opinions for a number of years, I work at making things direct and as simple as I can make them. So what I've done is I've taken a couple of the paragraphs that Stuart so eloquently wrote, and I've done a little wordsmithing. So if you look at your op-ed, the paragraph, it's from it's the third full paragraph from the end that starts with even before an announcement is made. Okay, that first sentence is fine. And ends with no inside games played. The next sentence, though, I have changed to public officials cannot tell their employees before the bid or proposal is prepared and advertised who they want to be the winner of the project. And the last sentence is fine. They cannot allow the public competitive bidding or proposal processes to be a sham. So I've made one change with one sentence. Then in the next paragraph, I've sort of turned it around and I've tried to focus on the case planning and design, because that was a case where the city of Santa Fe awarded the proposal to someone who didn't have the most points. So in that particular paragraph, the next paragraph, I've started it with, nor can they short circuit the evaluation requirements of the procurement code. In planning and designing, and we put a short cite there, the governing body rejected the recommendation of the selection committee and awarded the contract to a local firm, even though its proposal had not received the highest score. As the New Mexico, and this is from the editorial, as the New Mexico Supreme Court stated in that case, the procurement code protects against the evils of favoritism, nepotism, patronage, collusion, fraud, and corruption in the award of public contracts. Public officials cannot disregard the evaluation criteria or the final scoring determination when an award is to be made. And then the last sentence is the same that's in the op-ed. All public officials and employees and the public I changed it a little bit, must be aware of and follow the procurement code to ensure there is always fair dealing when it comes to the expenditure of public funds. And the reason I think that this particular op-ed is good at this particular time of the year is because there's three things that people need to be reminded about. Number one, there's no pre-selection. Number two, you've got to follow the code to set up the bid and do the evaluation process. And then it must be awarded to the person according to your evaluation process who has the highest score. So with this in mind and with these changes, I think that it's a good idea for the commission to be proactive and remind people that the procurement code is an important part of New Mexico law to uphold the ethics of people in state government.
All right, I assume you accept those amendments, Stuart?
Absolutely. I think they make it
Okay,
better.
there is a motion in a second. Any further discussion? Commissioner Baker?
Yeah, I've got serious reservations about not educational initiatives, not about the importance of the procurement code, but I've got serious reservations about individual commissioners taking it upon themselves to want to write something and get the approval of the commission and have it published. I think if we want to educate the public, we have very good staff who have the ability to do that, and to do that pursuant to a directive from the commission. Here we're kind of going backwards. We've got the tail wagging the dog. And I don't want anybody to think that I am against the importance of the procurement code, because I'm not. And I don't want anyone to think that I'm against educational initiatives, because I'm not. But I want them to come from a directive from the commission to say, we want you to do X. We have very qualified, capable people who can do that if we as a commission want it done. For example, we can do it with the Governmental Conduct Act, we can do it with the Campaign Reporting Act, we can do it with a number of other issues. If I was going to write this, I would write it different. My style is different from Stuart's. I feel like Commissioner Bluestone is hijacking the commission with this. I've written something in defense of God, country, and the American flag, and I want you to endorse it. And if you do not endorse it, there must be something wrong with you. I feel like I'm being set up, and I don't like it. And I'm saying it as bluntly as I can and as politely as I can. I don't like the initiative. I don't like the way that this has been brought before the commission. Thank you.
Thank you. Well, as luck would have it, Stuart, it's your turn to talk.
Well, I guess I'll try to respond to Jeff. And I'm sorry he feels that way. I'm not trying to hijack anything. I'm just trying to promote our public education role. I did talk to Jeremy a while ago about doing a procurement code op-ed and other op-eds to get out our public education mission. And I know that the staff is busy. And I know Jeremy said at one point that he had gone on ChatGPT, that AI feature, to do something on the procurement code, and it came up with something that he described as very similar to what this is. So I just think that I'm trying to help the process along. I'm not trying to hinder it or hijack anything or force anything on anybody. I think it's just a matter of whether we as the commission think this is doing a good public service and promoting our public education role. I mean, I can imagine that there are other issues that we can turn to the staff and others if they have the time to prepare. I know we're getting into campaign season, and I think maybe we've even done an op-ed before on what candidates need to be aware of as we get into the campaign season and what the public needs to be aware of, so that the laws are followed and there aren't hidden dark money efforts that aren't being disclosed. And there are all kinds of issues that we can address. And this is simply an effort to try to get a good public education piece out there for promoting the commission's interest in public education and the importance of this procurement code, particularly right now, as Commissioner Castillo said, with these RFPs that are about to be let out. So I'm sorry Jeff feels that way. I've tried to work with the commissioners over the last and I just think it's a good place, and that's why I think if the commission thinks that it wants to agree with this kind of public education, that it'll endorse it. But if not, for whatever reasons, that's something I'll respect and respectfully disagree with. But I think this serves our public education role. I think the procurement code is important, and we need to remind the public and public officials and employees about those important provisions and guardrails. And I think this piece does it and serves the commission's interest in doing so. So that's why I'm recommending it.
Thank you. Commissioner Castillo, do you have any further comments you'd like to make?
No, I don't. I will say though, I'm sorry that Jeff feels this way, and I do think that this does serve a public service. So that's all I'll say.
Thank you. Commissioner McMillan? Anything?
Thank you. I would make a couple of comments. I think perhaps the commission does have a role in educating the public. I'm not sure how far that goes and how much we are best served by simply allowing appropriate media coverage of our actions, educate the public about what we do. I have no objection to the way the piece is written, and it is in fact very educational for those who have the diligence to read it in its entirety. I have concerns about how it is being presented. In my experience, the editorial page of the newspaper is, of course, where political opinions are rendered, and those who read that page are there to read opinions. I don't consider this piece to be an opinion. It is informational in nature and educational. I fear that those who might read the piece and a name under it will be relegated to subjectively deciding if this person is on one side or the other of the aisle. This happens almost unconsciously when an individual's name appears under a piece in the editorial page. I think the integrity of our commission requires that we, in every respect, to the degree we can, remain nonpartisan as an organization. I would observe that I think, in my experience, and it is limited, but I have submitted and had opinions published. This is much too long for to appear in an op-ed. I may be wrong about that, and other experience may be different. I would submit for the commission's consideration an alternative. If the commission decides that this should be printed and identified with the commission, perhaps the approach should be that we actually purchase the space necessary, and that it be attributed to the commission itself, not to any individual member. Having made those observations, I'll relinquish the floor.
Thank you. Commissioner Solomon?
Thank you, Chair, and board colleagues. With greatest respect for Stuart, and I think what he's trying to accomplish, I think he's very well intentioned, and no matter, of course, this Stuart, this looks better and better the more distance we have from the matter that we considered, and that's what's driving this the need for an op-ed at one point in time. We understood your intentions, and I know that they're good. I just don't, I still can't come around to the point where I feel comfortable doing this kind of thing, authorizing as part of the commission this to be published and just under your name. That I think, as Commissioner McMillan discussed, when you do this kind of thing in the paper, and there's always the political realm that we deal with, and this can be interpreted in different ways, and sometimes against either the individual in this case and or the commission as a whole. The matter that drove this was, something that took a lot of consideration and special time allowance, for all of us to deal with. And I think it's best handled because in that particular matter, definitely was in the minority at that point in time, and it does sort of drive the tendency to issue some kind of minority opinion. And I still kind of see this in that realm. And forgive me, but I can't see it any other way at this point. And I think it does belong in the educational aspect of what we do as a commission and what our staff does. We just saw a list, of course, when this email was sent out to us by Jeremy, of all the things that they're doing to educate the public. And I think this is a good basis for educating the public, but not through an op-ed. So I respect this piece that you did very much, and think it really ought to be a part of our educational efforts for the public and for those in public office when it gets to that detail of who we're trying to convince that they should act in accordance with the codes and laws that apply to procurement, especially. So I just and the other thing, just to kind of reiterate and reflect on what drove this. I think the decision that we make need to be affirmed, even though we're in the minority and we have a different opinion from the majority when we have to make difficult decisions like this. And I think that we need to have an affirmation process that just sort of settles the matter, and that whatever we say or do needs to reflect our affirmation as commissioners. I just see that as part of our own sort of code of conduct, in terms of carrying out our duties and responsibilities, because I think we do the best we can. We interpret the facts in relation to the law, as everybody is trained to do pretty much on this commission. So I just feel like this is a good effort, but I think it belongs in a different kind of venue for the commission, and that's pretty much in the educational realm. So, and then I also think that affirmation of what we do shouldn't be diminished in any way by separate actions on the part of us individually when we're in public, or we have a public audience that we can address. And I think that's kind of what's trying to happen here. I just I can't go along with that at this point in time. So with all due respect, Stuart, I just can't support the commission issuing this document. Thank you very much, Mr. Chair.
Thank you, Commissioner Solomon. Commissioner Villanueva?
Yes, I have no issues with the piece that Commissioner Bluestone wrote. I think it was well written. I think it's educational. I think it's informational. I think it's helpful for the general public to know that we do have these laws. My issue is that he first approached it as an op-ed. In general, op-eds are vehicles that are meant to express the opinions of the author, And I don't believe it's proper business for the commission to be endorsing or to be asked to endorse works that were written with the intent of that work being placed in an opinion column. I don't believe that the commission should be involved in endorsing opinions. If I think the piece is well written, I think that it could go as a feature story if submitted to the paper. And I think Commissioner has the right under the First Amendment to write it, and I certainly respect that. But I also would not support approving it under the commission's name.
Yeah, and for my comments, I would everybody has a First Amendment right to submit what they want under their own name. But asking for the imprimatur of the commission, I have a few problems with it, not the least of which were raised by Commissioner Solomon. If there was, which I was not a part of, an action taken by the commission, it should lie as such. And there's danger that this could put upset that balance that the commission has heretofore maintained in terms of its own discussions. And further, to echo Judy's comments, Commissioner Villanueva's comments, that one always has the right to publish what one's own thoughts and opinions are. But I don't necessarily share in the entirety of it. The substance of it, clearly we all agree to, but tonally and temporally, I have some issues, so I would not support it. Is there any other discussion? Hearing none, we'll call a vote. Commissioner Baker?
No.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
No.
Commissioner Solomon?
No.
Commissioner Villanueva?
No.
And chair votes no. So the motion fails on a vote of 2 in the affirmative and 5 in the negative. The next item is number 10, which is the pre-closed session public comment. And I will leave it to you. Walker, this is generally your area, or has that shifted? Jane, is that you now?
Yeah, it's me now, but
I saw you
Easily we would
smiling,
forget.
so I figured that was it. What's that?
I say how easily we forget.
Well,
Jane
I did, but
Jane is now fully in charge.
yes, she had a big smile on her face, which suggested to me that she was indeed in charge. So,
and really briefly, Chair and Commissioners, I want to introduce Amy Ballou, who is a new hire with us. She joined Monday. She's from the Second Judicial Civil Division of the Second Judicial District Court. So Amy, if you want to introduce yourself really quickly.
Hello. I'm very pleased to be the State Ethics Commission newest hire. Thank you so much.
Amy, would you mind terribly putting your video on so we might all be able to recognize you at our next encounter?
Absolutely. Here we
Thank
go.
Thank you. It's always welcome. It's always good to welcome a fellow refugee from the Second Judicial District Court.
Thank you so much, sir.
You bet. All right, as the public.
Yeah, so if any members of the public are here to make a comment, you can use the raise hand function and I'll go ahead and call on you and you're free to make your comment.
I see a hand raised.
Yeah, Nat Dean, you can go ahead and make a comment.
Thank you, members of the commission. I would like to express appreciation for having accurate closed captioning during this Zoom meeting. It is very much appreciated. It is an accommodation that may not seem logical in all cases, but there is not, just as there is not one person that is the same as the next person, there is not one hearing loss, one auditory processing disorder, or one case of deafness that is the same as any other. And I appreciate the embracing of a community which has very divergent and multiplicity of needs. Thank you very much.
You're welcome, ma'am. Thank you for joining us. Anybody else, Jane?
It doesn't look like anyone else.
All right. Thank you. Then Chair will entertain the applicable motion for the commission to go into executive session as allowed by law. Is there a motion
So
second?
moved.
Second.
All right. Anybody opposed? Hearing none, we will move into closed section. Is there a collective, a consensus that we should take a 5-minute break while we reset? Yeah, seeing some thumbs up and some nods. So we'll be back in 5 minutes, after which time we will be in our own room. Note that we are all unmuted until we take action to otherwise present. All right. 2, 3, 4, 5, 6, 7. We are back in open session. Jane, are we good to go?
Yeah, we're recording. We're good to go.
Thank you. All right. We're now in open session. Item number 14 is authorization of civil action. Walker.
Thank you, Chair and Commissioners. Commission staff would seek a motion approving a proposed pre-litigation settlement agreement with Mr. Ron Senna, the manager of the Village of Ruidoso, settling claims, settling admitted violations of Section 1016 3.1 of the Governmental Conduct Act.
There a motion, a second?
So moved.
Second. Is there a second? I didn't hear anybody else besides Stuart.
Second.
Okay, probably because I was talking. All right, any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon, McMillan, I'm sorry,
Yes.
Commissioner Solomon, Commissioner Villanueva.
Yes.
Thank you. Chair votes yes. Motion carries. Item number 15, Rebecca.
Chair, Commissioners, in 2023 NPO 7 INRAE Commission of McNellis, Commission staff request approval of the settlement agreement.
Your motion is second?
So
So
moved.
moved.
Moved and seconded. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon. You see a yes, and Commissioner Villanueva.
Yes.
Thank you. Chair votes yes. Motion carries. Settlement agreement is adopted. Item number or letter B, regarding a commission of Garza.
Chair and staff, or Chair and Commissioners, staff requests issuance of the default order in this matter.
Motion second.
So moved.
Thank you, Commissioner. Any discussion? Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon.
Yes.
Thank you, Commissioner Villanueva.
Yes.
And chair votes yes. I'll let the order issue, and your last one, Rebecca.
In 2024 NPO 1 INRAE Commission of Terrazas, staff request order of dismissal and issuance of the warning letter.
Thank you. Is there a motion, a second?
So moved.
Thank you. Moved and seconded. Commission, any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. So the request is granted. Thank you, Rebecca. And the next item is 16A, Jeremy.
Thank you, Chair. Chair and Commission, the staff requests an order of dismissal for lack of jurisdiction in administrative case number 2024-03.
Thank you. Is there a motion, a second?
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. The request is granted. All right, discussion of the next meeting. Jeremy sent around a at the commissioner's request, who will be indisposed in a great way. Whether we could see fit to move the next meeting up, that would be to May 24th. Does that work for everybody?
It works for me.
Yes.
It will or not? I'm sorry, Jeff, yes or no?
Yes.
Okay, so how about, are there any no's it can't work for me? Okay, so we'll go ahead and set the next meeting for May 24th. And thank you for that. And the next item is the second round of public comment. And Jane, I will let you search for that.
Yeah, if there's any members of the public who would like to make a comment at this time, please raise your hand and we'll call on you to make your comment. I'm not seeing any hands raised.
All righty. There being no further business commission today, we will adjourn. Thank you, everybody, for your good offices, and we'll see you down the road.